Imagine a high-stakes trial. A victim is seeking millions in compensation, or a defendant is pleading not guilty by reason of insanity. The person taking this exact seat to testify isn't an eyewitness, it's a psychologist. When we think of a psychologist, we usually picture a therapist. We expect an empathetic advocate who creates a safe, trusting space to help their patient heal. But the forensic model works differently. In a clinical setting, the relationship is a straight line between doctor and patient. In this triangular forensic model, the psychologist evaluates the individual on the couch, but they actually work for the court. Because the court is the actual client, the psychologist's obligation changes. Their goal is no longer subjective therapeutic healing. It is objective fact-finding for a judge or jury. This shift in agency means forensic psychologists interact with victims and offenders as investigators rather than allies, stripping away advocacy to focus on the production of verifiable data for the legal record. So, how does this work when evaluating a victim claiming trauma? The forensic psychologist isn't there to offer therapy sessions. They act as an investigator, assessing the validity and scope of a psychological injury. In high-value personal injury lawsuits, they have to determine the actual severity of the distress. Courts differentiate between garden-variety emotional pain and egregious emotional distress, and financial damages scale accordingly. To measure this, evaluators use psychometric testing to isolate the effects of the specific event. This allows them to separate the trauma caused by a recent accident from a victim's pre-existing history or childhood trauma. Even though they aren't therapists, forensic psychologists do facilitate healing through restorative justice programs within secure mental health settings. These are highly structured meetings between victims and defenders. For victims of violent crimes committed by someone deemed legally insane, getting direct answers from the offender can help process trauma in ways a standard legal verdict cannot. By maintaining strict, objective boundaries, the psychologist provides the court with verified evidence. This data validates a victim's genuine trauma through a rigorous process that is more useful to the court than blind advocacy. When forensic psychologists evaluate violent offenders, there is a common public fear that explaining a criminal's mental state is the same thing as trying to excuse their behavior. That's where specific legal standards come in. Competency to stand trial focuses on the present day. It asks if a defendant currently has the cognitive ability to understand the courtroom proceedings and assist their lawyer. That is a separate task from evaluating legal insanity. An insanity defense requires a backward-looking evaluation to determine the defendant's mental state at the exact moment the crime was committed. Evaluators apply a trauma-informed lens to these assessments. They map out an offender's background and exposure to adversity to scientifically understand the mechanics of their actions without legally absolving them of responsibility. Explaining the psychological drivers behind a crime is a tool for the legal system. It helps judges determine appropriate sentencing and gauge the risk of future violence, rather than serving as a shield for the defense. Sometimes an offender will try to game the system through malingering. This is the intentional exaggeration or fabrication of symptoms to achieve a gain, like avoiding a prison sentence. Historically, catching a liar meant relying on physiological arousal. Instruments like the vintage polygraph tracked pulse rate and skin conductivity, assuming deception always triggered physical anxiety. But these results were often unreliable and vulnerable to simple countermeasures. Modern methods focus on cognitive load. Truth-telling is simple memory retrieval, a straight line. Deception requires heavy mental friction, creating a tangled web. Evaluators use this in forced choice tests. Pure guessing yields a 50% success rate. Scoring significantly lower statistically proves intentional failure. They also use symptom validity testing to catch amplified presentations. This involves checking if an offender eagerly endorses absurd or clinically impossible combinations of symptoms that genuine psychiatric patients never report. Another tactic is restricting response times with rapid-fire questions. By forcing an immediate answer, the evaluator overloads working memory until their fabricated narrative collapses. These scientific checks against manipulation ensure the forensic psychologist operates as an impartial investigator, prioritizing the integrity of the data over any allegiance to the offender's personal goals. If the forensic psychologist doesn't serve the victim or the offender, does that mean they are just a hired gun for whichever legal team pays their invoice? To prevent that, the field follows strict ethical boundaries. First, there is a ban on dual relationships. A treating therapist can never serve as a forensic evaluator for their own patient, because the required neutrality would compromise the therapeutic trust. Second, there is a prohibition against contingency fees. A forensic psychologist's compensation can never be tied to the verdict or settlement of a trial, removing the financial incentive to skew findings. Psychologists can also operate as non-testifying consultants. In this role, they are hired solely to critique the methodology and tests used by opposing experts, ensuring the science presented to the court is accurate and sound. Whether testifying in court or consulting behind the scenes, these professionals act as the link between psychological science and legal standards, converting the nuances of the human mind into evidence the justice system can actually use.